Nothing has been more of a lightning rod to the discussion about justice reform and how far to go than the question about bail reform. You see this all over the country. It's being now used as an excuse or a reason to recall some of the progressive prosecutors or reform prosecutors. The visible image of reform is really in bail is kind of an object of fury to a lot of our opponents, the traditional opponents, who blame it for rising crime. And I think that it's probably good to stand back a little bit and take a closer look, a cooler look at what it all means, what bail reform is and what it isn't. And I'm very pleased to have with us some really key speakers in this field to talk about it. I'd like to start first with Satana Deberry, who is the prosecutor, the DA in Durham County, North Carolina. She's written on what bail reform has meant in her area. She is a former defender, a defense attorney, so she brings that perspective to the work. So, Mr. Deberry, DA Deberry, over to you as a start. Thank you for joining us.
Thank you for having me. I'm really excited to be with y'all today, and I'm going to share my screen and give you a couple slides. I have 10 minutes as way of introduction. So I want to talk a little bit about what we've done here in Durham, just give you a fuller picture of kind of what bail reform has looked like on the local level. As soon as I find my screen to share, we've been 2 years doing this and still always having trouble setting up a slideshow. All right.
Understood.
So what are you all actually seeing?
We see it. It's perfect.
Is it perfect? Is it at the beginning of the slide, or is it?
It says related studies, so it might be.
Okay, so we're going to start at the beginning of the slideshow, and I have 3 screens. So again, it makes it. So now, do you have the?
There you go.
Beginning page. Great. All right. So, just as we get started, I want to make sure that we all start from the same place on what the role of the DA is. Often we find that we have to remind people that our primary goal is not the conviction of people and keeping people in locked up. We serve the public interest and act in the interest of our community, and really we want to balance our judgment to both increase public safety, but also protect the innocent and those of us in our community who are the most vulnerable, whether they be victims or defendants. Real quickly, this is a 2019 slide, but our most recent 2020 slide and 2021 slides look about the same. So it's helpful when we're talking about bail reform to really talk about what a prosecutor's office caseload looks like. Our caseload in Durham County, for the most part, fully half of what we do is traffic. Very, very small part of what we do, about 30% of what we do is misdemeanors, and then another 20% is felonies, and then only 12% of what we do is violent crime. Our top charges are things like speeding and no operator's license. Even when we exclude traffic, our top charges are misdemeanor larceny, possession of drug paraphernalia, obtaining property by false pretenses, which in North Carolina is most likely stealing something and then pawning it. Our most common violent felonies are robbery, assault by strangulation, and those type of things. And in North Carolina, we have both felonies and misdemeanors in 2 crime classes. And this is just a setup when I start talking about what lower level means, what that means here in North Carolina. So our felonies are A through E, which are generally crimes against people. F through I are generally drug, property, and gun possession crimes. They generally do not have actual victims. And misdemeanors are some combination of victim crimes and property crimes. So in 2019, my office instituted a new pretrial release policy that focuses really on creating a bail reform system where we only keep locked up those people who are a danger to themselves or to others. The North Carolina Constitution actually sets forth who is entitled to bond, and everyone in North Carolina who has been charged with a crime is entitled to a bond, except for someone who has been charged with first-degree murder and faces the death penalty. We don't use the death penalty here in my office, so everyone in Durham County is entitled to a bond, and our pretrial release policy in our office sets up how we talk about that to judges and to victims and what we do recommend. So here we recommend release conditions. Our judges or magistrates ultimately set them. Our policy, we do not have a suggested bond schedule, so my prosecutors are not asked to, in say, for example, class I felonies, to set a bond between 0 and 1,000. Really where we break is we make our distinctions based on use of threat or force rather than the crime class. To the extent possible, we remove money at all from the consideration of bond. And we really only want the court to be making a binary choice, whether that choice is to release this person or detain that person. Like I've said earlier, under North Carolina law, most people have a right to pretrial release conditions. First-degree murder is the most common exceptions. The less common exceptions are firearm offense with a prior history, drug trafficking, and gang activity. Again, we always have to remind people that anyone being held pretrial is legally presumed innocent, and certainly one of the things that we have seen with the rise in violent crime is that people want to keep more people locked up out of fear, not out of real understanding of who those people are that are locked up. We take that seriously when we're trying to make this binary decision. We want to weigh the strength of the evidence, and we really want to think about ethically whether or not we are presenting to the court the appropriate information. In North Carolina law, you'll see down here what conditions can be set. I have these numbered, but these are actually in constitutionally preferred order. So North Carolina Constitution prefers that most people be given a written promise to appear. If you cannot do that, if they are too dangerous or risk of flight for that, then a custody release, which is, say, a release to a family member or a program. If that cannot be accomplished, they are to set an unsecured bond. If an unsecured bond does not address issues of dangerousness or flight, a secured bond. And then finally, the last thing is electronic monitoring or house arrest. We actually had to break out this process a little bit to understand when we wanted to, how these decisions were made so that our prosecutors could understand really where it was best to intervene and make their recommendations. And so our policy really is kind of a complex determination that considers not just the nature of the offense, but a risk assessment, that person's proximity to violence, as well as their individual circumstances. So the way that is broken down is that basically all infractions and nonviolent misdemeanors are a blanket written promise to appear. We do not ask for a bond at all in those cases. For nonviolent felony, the same. We generally ask for a written promise. If we ask for custody release, that custody release is generally to a substance abuse program or to a mental health program. Any offenses that involve violence, depending on the risk and the proximity, again, start with the written promise, proceed to custody order, monitoring, or house arrest before we ask for an unattainable secured bond. And generally, we do not ask for no bond or an unattainable bond, only in what it's come down to in our jurisdiction is murder cases. We have a general indictment for murder, and then sexual assaults and armed robberies.
So if I may, the DA of Deberry, if I can just cut in for a second there, the level of detail here is really fascinating. You're an elected DA, and what I'm interested in is the level of buy-in that you've had so far from your community. You've written a really fascinating op-ed, which I recommend that people read, about the impact on public safety and on crime levels in your county. But I wonder if you could talk a little bit about the politics of what you've done. I mean, was it difficult to get this introduced? Did you have a lot of pushback from judges, from local politicians? And if you did, how did you counter that?
Yeah, sure. I'll talk a little bit about the politics. We were, I am, to probably no one's surprise, I was elected on a reform agenda. And one of the things that had become a concern in my community was cash bail. We have several community activists and organizations that were working towards the reform of cash bail in our county. We had several programs which have now become national programs, like the Black Mama Bailout, where local activists were raising money. And if you looked at the Durham County, if you looked at the daily population of the Durham County Jail, there were hundreds of people who were there because they could not afford not to be. So what it ended up looking like was that there were lots of people who were given $5,000 bonds, which to a judge sounded like a low bond because they only had to come up with $500. But $500 is a lot when you are paycheck to paycheck. And so one of the things that I had promised in my campaign, and one of the things that certainly our community held me accountable for, was a bond policy that did not favor a cash bond for people who were not dangerous or for people who had been charged with low-level crimes. And so it has been a very popular with the community, very kind of unpopular at the beginning with our judges. We found that the real friction point were judges who had a bond schedule that they were used to using that didn't really conform to North Carolina constitutional law, but that they didn't care about. What they were most concerned about was that 1 in a million chance that somebody who had been charged with misdemeanor larceny would later go on to murder somebody.
Right.
And so one of the things that we've done around community education, and why I talked about this earlier in my presentation, was to really have a transparent look at what the people are charged with who are generally in our jail. And so what has happened now is that over these past 3 years, we have about a 25% reduction in our daily jail population. We've actually been looking at it a little bit more closely lately, because what we've noticed is the numbers starting to go up a little bit, despite our kind of daily efforts at looking at who's on cash bail. We have these low bond meetings where if anybody has a bond set of $20,000 or more, my office initiates contact with the defense attorney to negotiate some type of release.
Has that rise created an opening for your opponents?
Well, no, actually, I don't know yet. We'll see. I just had 2 people file against me this week, so we'll see if that. But the truth of that rise is what we've seen is that our detention facility now is holding people for other jurisdictions. Our numbers are actually probably even closer to 30 or 40% lower for pretrial detention. but that gap between our pretrial detainees and the detention facilities capacity has created the opportunity for federal detainees, as well as detainees from other jurisdictions.
Okay, I want to go on to the other speakers as well, so we have some time, but I will come back to you on the politics of it, and particularly an area that you mentioned, which has gotten a lot of press here in New York, which is having judges decide or define what the level of dangerousness means, which is, I think probably the most controversial part of the bail reform and the opposition to bail reform here in New York. But let me move to Mike Rempel, who is the director of the Data Collaborative for Justice at John Jay College right now, but until recently, he was director of jail reform at the Center for Court Innovation. And he has done, as you can see on the screen, an amazing report on the New York experience of bail, which punctures a lot of the myths about what bail reform has achieved and what it hasn't achieved. So Mike, over to you.
Okay, well, first of all, Stephen, can you hear me and can you all see?
We can, and we can see you. Yes.
All right, fantastic. So, so my job for, I guess, the next 12 or so minutes is to talk about New York's bail reform achieved through law at the state level. So I'd like to go through 3 issues quickly. What is New York's bail reform? What are the results to date? And do any of those results help us understand whether there is a connection between New York's law and recidivism? Okay, but before we get to that, let's just step back for a moment and talk about the goals of bail reform. And I want to classify the most often discussed goals in New York nationally as 4: reduce pretrial detention and its harms, mitigate the criminalization of poverty, which is seen when people can't afford bail, even though I should open a parentheses and observe that the historic purpose of money bail was never to detain people. It was actually to facilitate the release of people and to provide a money incentive for them to return to court. Yet it often results in detention, so that leads to the second goal. Third, to curtail the racial disparities that often result in who is detained as a result of an inability to afford bail. And fourth, to achieve these first 3 goals without in any way compromising public safety. So here in New York's reforms, they don't eliminate bail. They partially eliminate bail and detention by banning it for most misdemeanors and most non-violent felonies, but all violent felonies, or nearly all violent felonies, remain bail eligible. So for the rest of this presentation, we're going to talk about bail eligible cases. That's going to be mostly violent felonies, and bail ineligible cases where bail was banned, and that is mostly misdemeanors and non-violent felonies. So in addition to this popular provision, right, the law also required judges to have discretion to order supervised release in any case, whether bail eligible or not. It required judges to consider people's ability to afford bail when they wish to set bail. It established a new presumption of release, which said that actually courts are not supposed to set any pretrial conditions at all, supervised release, bail, or any other conditions, unless there is evidence the individual poses a risk of flight. So there's a presumption of release without conditions. And then when someone does have a risk of flight, the law said that courts should impose the least restrictive condition necessary to assure court attendance. Okay, so that law went into effect at the beginning of 2000, but in the middle of 2000, amendments were passed. And the amendments did 2 main things. It made about a dozen charges and categories of cases that had been made ineligible for bail and put them back into the eligible for bail category. And then, less widely known, the amendments also established a number of additional non-monetary conditions besides supervised release, most notably treatment that judges could order in lieu of bail. All right, so let's look at some results. So let's start with statewide results. So 2019 pre-bail reform, 2020 bail reform. So just generally, 1 year to the next, we saw a 12 percentage point reduction statewide in percentage of cases facing bail. In felony cases, we actually saw a larger reduction at 25 percentage point reduction. And if we were to drill down further, we would mostly see this large reduction on the non-violent felonies, less so on the violent felonies. And I'm going to show more on that in a moment. This is just New York City. And can I just acknowledge my colleague on this slide and the next several slides, Joanna Weil, who worked with me on this project last year. So this is New York City only, not state. On the left, we're looking at misdemeanors, 19 to 20, and we immediately see that there wasn't much of an effect on misdemeanors, and that is because even before bail reform went into effect, judges only chose bail in 8% of misdemeanor cases. We see a large effect on these non-violent felony cases where bail setting declined by just over 20 percentage points. And we also see a reduction in bail setting on violent felony cases, even though they remained eligible for bail. And that is because judges, given the option to set supervised release, instead actually availed themselves of that option some at a time. And so that accounts for this 12 percentage point drop here. Okay, so that's the overall effect 2019-2020. But now we're going to get a little bit more complicated. So what we're looking at here is for every month, the percentage of cases where judges set bail, and the purple is violent felonies, the blue is non-violent felonies, the gray is misdemeanors. So I'm just going to go to the basic takeaways that I'm hoping people can see on the slide. Bail reform is implemented at the beginning of 2020, and we can see a drop in all categories. The pandemic begins in March of 2020, and we actually don't see much change in the immediate aftermath of the pandemic and bail setting. Then really a little bit later, in about May 2020, we see a re-increase in bail setting, not to the earlier 2019 levels, but we do see a re-increase, and we're going to talk about that a little bit more. So one reason for this re-increase has to do with the amendments that were passed, which we said earlier made about 24 more categories of cases re-eligible for bail. And in fact, we found that in the second half of 2020, of all people in the city who faced bail, 18% of those people faced it expressly due to the amendments. But I want to go back to what happened with the amendments and this idea that there were a dozen provisions in the amendments. We actually found there were only two extremely impactful ones, and that was making a subcategory of burglary in the second degree cases where essentially people are unlawfully in someone else's living area eligible for bail, and the what is often referred to as the harm provision, where judges are allowed to set bail even in misdemeanor or non-violent felony cases if the current case and an open unresolved case involves, in the judge's view, harm to a personal property. And so violent felonies were already eligible for bail. So it's really harm to property that is having the biggest impact here. All right, so let's sum all this up. Why did we see this re-increase in bail setting around mid-year 2020? The bail amendments was one reason, but it was not the only reason, because again, the re-increase started in May before the amendments went into effect. And we also did further research and found that judges were changing their practices on cases eligible for bail throughout the year. So we have theory number 2, which I'm calling the reversion to the mean theory. Judges received extensive training on the reforms, extensive training on supervised release towards the end of 2019. The pandemic made it difficult to engage in retraining. So we might be looking at a kind of a reversion to the mean, a reversion to bail setting on those largely violent felony cases where it's always been eligible. We might also be looking at violent crime fears, because remember, it was right about May where we saw this uptick in bail setting, and where we also saw the beginnings of the widely reported uptick in gun violence. So those are our theories. I'll come back to the third one later. All right, I'm just going to go through a few other things quickly. Affordability. So this is what we call an implementation problem. The law said that courts were supposed to start considering people's individual financial circumstances under reform, but we can see that there really wasn't a change in bail payment rates of people who actually faced bail between 2019 and 2020. Okay, this is what we call another implementation problem. So if we look at 2019 and the early part of 2020, we're actually seeing a slight reduction or really no change in racial disparities in bail setting. But in the end of 2020, when bail setting went up generally, if we can focus on this 21% statistic, what we're seeing is by the fourth quarter of 2020, we actually have an outcome where Black New Yorkers facing violent felony charges were 21 percentage points more likely to face bail than white New Yorkers facing violent felony charges. And this changed from earlier in the year. All right. This is the last technical slide I'm going to present to you. Never mind about the details. Nobody viewing this, focus on the numbers, just focus on the spread of the purple. What we're showing you here is that in 2019, there's wide variability in different judges' likelihoods of setting bail. Around 8 judges, right, set it under 10% of the time in 2019. And we have a spread of judges that are setting it 40%, 50%, 60% in 2019. And then what we're showing is that the range of judges' tendencies were constrained, which has an obvious explanation because bail was banned in a large swath of those misdemeanor nonviolent felony cases. And in fact, what we also found is that in the violent felony cases that remained eligible for bail, we did not see this reduction in what we're calling judicial inconsistency. So in 2020, we still had a judge who set bail in 23% of violent felonies and one who set bail in 71% of violent felonies. But again, going back to the overall, we are seeing this dynamic of a pretty significant constraining of inconsistency based upon the judge who hears your case.
So, Mike, if I could just, do you have one more point to make, or just, I have a question on it?
Oh, I wanted to just go in the last direction on bail reform and crime, but maybe we
Right.
can pause since I was about to move to a different topic for the last slide.
Okay, let me just put this out in front of you. That one of the reasons for bail reform has always been to reduce recidivism, reduce criminogenic behavior, and also to increase the economic prospects of people who ordinarily, if they were held pre-trial, were more likely to lose jobs, to have family problems. That is very hard to measure by data statistically, but I wonder if there's any way, any comparison that's been made between the economic prospects, between people who haven't lost their jobs because they've retained them, because they haven't had to be held and they can just wait for the actual trial. Is there any way to measure that, whether those goals of the bail reform system actually worked, even in the short time we saw the bail reform implemented in New York?
Oh, well, actually, so Stephen, that's a fantastic question because you maybe intentionally or unintentionally set me up for the slide. But let me first answer the sub question you had that's not part of the slide, which was on the economic effect. So no, in New York, it's not been looked at specifically, but there is research by the Brennan Center that in the past has sought to quantify the effects in the future of someone's employment prospects and
Right.
income across their lifetime, and has found that there's a significant effect of a conviction and then an even greater effect of incarceration. So on the crime question, so this is my very last slide on the crime question. If I could take that one too, I like to think in terms of 3 basic points in answering the question. And the first point is it's an unanswered question. Despite what anyone may have read, there is no credible study to date that has compared individuals who were detained prior to New York's bail reform and were then released in 2020 as a result of New York's bail reform. So it's an unanswered question. But secondly, based on what we do know, our expectation is that when this research will be done, we're going to find that bail reform will not increase recidivism, and so we expect to find that for three reasons. One is that in terms of what is often linked as the reason for connecting bail reform to crime, which is the uptick in gun violence, well, we know that's happened nationally. But second, prior bail reform evaluations in New Jersey, Chicago, Philadelphia have found no effect on recidivism rates. And then thirdly, prior research, not on a bail reform law specifically, but just on effects of detaining versus releasing similar types of individuals, and I've listed the cities where this kind of research has been done, has actually found that in the long run, it's pretrial detention and not releasing people that will increase recidivism, which gets to the final point, which is that to understand this, you have to measure recidivism in both the pretrial period and the subsequent period of time, because we know that if we incapacitate people pre-trial, we're going to suppress recidivism since they're incapacitated, they're in jail. But the prior research suggests that those people who incapacitate pre-trial then become more likely to reoffend after they are inevitably, eventually released. So that's why when this unanswered question is answered, hopefully the answer will provide insight into both the pretrial period and a longer term period of time. And that's really all I have. The last slide is takeaways. And I'll just, well, Stephen, I know you're going to do an introduction, but I just want to tee up Cindy, who did a fascinating study in New Jersey's bail reform, and I know she's going to talk about that in a moment.
Right. So I want to go back to Mr. Deberry as well to ask her her experience in Durham about recidivism. But before I do that, I wanted to bring Cindy in because when we think about bail reform, we think primarily of the major player, which is basically judges who make the decisions or don't make the decisions or decide on dangerousness and what. But you know, the role of the attorneys, and particularly defense attorneys, this is obviously crucial. Hasn't really been talked about a lot. So, and Cindy, you're at the Bronx District Attorney's Office. Maybe you can talk a little bit about what you've experienced and what the role, productive or non-productive, has been of attorneys in New York's bail reform.
Sure. Well, first I want to, thank everyone for having me. I'm really excited to join this panel. I'm looking forward to the conversation today. So in terms of, I do want to say something interesting related to that about New Jersey, which is, and I'm going to talk a little more about that, but interestingly in New Jersey, there's such a thing as preventive detention. So that means a judge theoretically can basically decide to detain someone without bail if they feel that there's a risk to public safety or they are a risk of flight. But in New Jersey, that initial decision is actually determined by the prosecutor. So the judge cannot choose to detain someone unless the prosecutor motions for that person to be detained. But we'll talk more about that. But I think that is really kind of fascinating and very different from what happens in many places.
Is that in the legislative guidelines, or is that just something out of, is it a practice that's developed over there?
I'm not sure that I know for sure whether it's in the guidelines. It's definitely, it's practiced. It's it's what happens. So I believe it's consistent through all statewide courts. So I would suspect that it is a legislative a law. Yes. So and then I recently joined the Bronx District Attorney's Office, and this is also a nice tee up for me to say that what I'm going to talk about today in terms of New Jersey's reforms and the rigorous evaluation that was done there was in my prior life. So it is not as part, I did not do that study as part of my work here with the Bronx District Attorney's Office, and the results really aren't, they don't represent necessarily the views of this office. But being here, so I haven't been here that long. It's been about 6 months. So I can say that and I don't know if the district attorney, Darcel Clark is the district attorney in the Bronx, if she, represents national district attorneys, but she's very much pro bail reform. She and the office, even before bail reform was enacted, the office had a policy of a presumption of release. So a bail, we suspect, we haven't studied it yet, but we suspect that the impact in the Bronx of bail reform is probably going to be smaller than it is in other places, because the office policy did not result, even before bail reform, in many people having bail set. So hopefully that answers your question about,
Yes.
I'm not sure if it's, it was kind of long-winded. So are
Yes,
there
go
other
ahead.
questions? Okay, so I'm going to share my screen, and I'm going to just talk a little bit about New Jersey's bail reform and the effects. And I'm going to link it back. I'm going to try to do some comparisons, give some insight about how to think about New Jersey's results in the context of
Yeah.
what we're seeing in New York. Okay, can you all see my screen?
Yes.
Okay, great. All right. 1 second. Okay. Okay, so I just want to talk first. This evaluation, as I mentioned earlier, was done. It was actually done back in 2018 and 2019. It was funded by Arnold Ventures, so it's separate from completely independent of the judiciary. And what we did was track outcomes for the first year after their what they call criminal justice reform was implemented. So the results that we're looking at are for our results in the first year after that bail reform was implemented, January 2017 through December 2017. And then I want to say a little bit about what exactly was tested. So what was part of these reforms, because it just kind of helps put everything in context. So it was the goal of the state when they implemented these reforms was to shift the state from a pretrial system that relied very heavily on the use of money bail to a risk-based system. And so that involved changes to, there actually had to be a ballot amendment to allow the state to take on these reforms. So it was a much longer process than what happened in New York. It took 2 to 3 years actually to get these reforms implemented. And it involved the use of a pretrial risk assessment called the public safety assessment. It involved starting a pretrial monitoring program like supervised release. It also included passing speedy trial laws. And importantly, it allowed for the option of pretrial detention for defendants that posed a risk to public safety. And it also ensured that public defenders could be present at the hearing. So there are a lot of components to this reform, and this study couldn't really isolate one component from another. So we studied the package. Okay, and I just want to say a little bit, quickly explain what the case process is in New Jersey, because it's quite different from New York and even from North Carolina, and it really helps kind of set the stage for understanding the impacts that I'm going to talk about. So first, the process begins with an arrest, as in most jurisdictions. And when a person is arrested in New Jersey, he or she is issued that arrest either on what's called a complaint warrant or a complaint summons. And in the equivalent in New York for terminology is that a complaint warrant is kind of like a live arrest or a summary arrest, whereas a complaint summons is analogous to a DAT or a desk appearance ticket. So as part of that process, there was a big change that came about with criminal justice reform, and that was the PSA, which is that risk assessment tool that I talked about, that was used, basically the cornerstone of the reforms, is actually used to inform that decision about what kind of arrest this is going to be, whether it's going to be a complaint warrant or a summons. And there's a big difference for the defendant, because if it's issued as a warrant, the defendant is detained, awaiting the first appearance hearing. Whereas if it's the arrest is issued as a summons, it's a desk appearance ticket and they are released and returned to court on their own. The next sort of stage in that process, once that decision is made, is sorry, I need my glasses actually. I want to remind myself. Yeah, so I want to say just one more thing about that process, which is that in order for an arresting officer to decide to arrest the defendant on a complaint warrant, they actually need a judicial officer to review the facts of the arrest, as well as review the initial risk assessment results. And so they have to kind of get permission to arrest someone on a warrant complaint. So then if the decision is made, there is approval to do that arrest as a warrant complaint, the defendant is booked into jail and awaits a first appearance hearing. And in that time frame between the arrest and the first appearance hearing, there's a lot more manual work done in terms of that risk assessment and decision-making framework, where a report is developed for all of the stakeholders to review on the record in the first appearance hearing, and it describes the person's risk assessment score, as well as gives a recommendation for the release. And so the hearing happens, this because of speedy trial laws, that first appearance hearing has to happen within 48 hours. In practice, it actually happened within 24 hours in most cases. And it used to take about a week before criminal justice reform and speedy trial laws. So after the first appearance hearing, that's where I mentioned earlier that the prosecutor can motion to detain the defendant for, it took about a week for a more complete hearing where they would decide what the ultimate pretrial release status would be. And in almost every situation, when prosecutor motioned to detain, the judge would detain the defendant at that point. So what did we find? I'm just going to quickly explain how to look at these slides and sort of how to read this analysis. It used an interrupted time series design to estimate the effects. And what the graphs show is the outcomes aggregated by month. So what this shows is every month between January 2014 and December 2017, it shows for the cases that were arrested in that month, that's what we're tracking. So that each monthly cohort is basically all cases that were initiated during that month. And what happens is that we use the past sort of early months and years to predict what would occur in the future. And then we compare after that criminal justice reform, what the prediction was versus what actually happened. And that difference is the impact. So in New Jersey, what's really interesting and kind of gives us more confidence in this methodology is how stable things were before that 2017, that January 2017 reform. And while this may not look very stable, these ups and downs are actually normal sort of crime patterns, with summer months being higher and winter months being having fewer arrests. But if you kind of smoothed it out, it's almost a straight line, and you'll see in the other slides. So we have a lot of confidence because of how stable things were before January 2017. And the interesting takeaway here, the interesting finding from this slide is that what you see here on the right is that there was a pretty steep reduction in the number of misdemeanor arrests that occurred after the criminal justice reform was implemented. Felony level arrests, which is called indictable in New Jersey, felony arrests were pretty much stable there. We don't see much of a deviation from the prediction, which is this gray line, to what actually happened, which is the black line. But for misdemeanor arrests, we see a pretty large deviation from what would have been predicted to occur had criminal justice reform not went into effect. And this slide focuses on that decision point that I was talking about, where it's basically the determination for whether the arrest will be issued as a desk appearance ticket or a summons versus a warrant. And what we see here is, again, this is where you can really see in the pre-period. I'm gonna use my pointer here. In this pre-period, you see how flat this is. So pretty consistently, a little over 50% of arrests were issued as complaint warrants before criminal justice reform. And then right after criminal justice reform, that drops pretty dramatically to just almost 40%. It goes to near 40%. But what we're seeing here is about an 8 percentage point reduction in arrests being issued on warrant complaints. And similarly, or alternatively, I guess you could say, is more arrests were then issued on summons complaints. What this slide is showing is the effects of criminal justice reform on jail detention. And again, see a lot, it's fairly stable pre-criminal justice reform, and then right after we see a pretty steep decline in jail stays, in the length of time that people were detained in jail after criminal justice reform. So for people in that category of being held for 10 or more days, we see a reduction of 7.6 percentage points. And the table at the bottom shows the numbers, but really what's most informative is really just to look at this graph and see the steep drop that happens literally right at the point of criminal justice reform. And this is a little bit different because what this slide is showing is the average daily population in the statewide jails. So the slide I showed before was those specific cases and defendants, pretrial defendants, and this is how many people are sitting in jail on a given day. And again, you can see as of January 2017, a steep decline, a very steep decline and large difference from what would have been predicted had criminal justice reform not been implemented. Okay, and this is a very complicated slide, but the most important thing to take away from here is that the impacts on jail detention were largest in places that had a higher rate of using pretrial detention before criminal justice reform. So this is similar to what I was saying about what we might expect in the Bronx, that in Morris County in New Jersey, the impact on jail detention was actually quite small and not really significant. So there was virtually no impact on jail detention in Morris County, New Jersey, because they rarely use jail detention before criminal justice reform. And then this slide shows, even with all of those reforms taking, the reductions that we observed in jail detention and virtual elimination of bail, there was very little effect on pretrial arrests. So that means new crimes being committed while people have an open case. And so what this figure is showing, the blue bars represent 2014 rate of pretrial rearrests, and the yellow bars are showing 2018 rate of rearrests while with pending cases. And you can see that on the left-hand side, these are those indictable felony offenses, and on the right-hand side, these are the very, very low-level offenses, which they call disorderly persons.
Cindy, if I could, I don't know how many, I've got a bunch more slides. I wanted to move on to a more general discussion with your key findings, so you can go, that's fine.
Yeah, I actually, yeah, so I'm not even going to review this slide, but I just want to get into the implications for New York, just sort of because I feel like this is important given all of the data that's being thrown around by journalists and in the media. I want to throw out some important points to consider when thinking about numbers and data and what the data is showing us right now in New York. As Mike alluded to, we don't really have any evidence yet in New York about the effects on recidivism and there really is no rigorous research or valid research showing the relationship between these bail reforms and the increases in violent crime that we're all seeing. And I want to just talk, I just want to make a few important points related to that, which is we've all seen this, that we know that bail reform in New York has resulted in less jail detention. But I want to point out that jail detention has been declining for 5 years in New York. So going all the way back to 2015, we're seeing every year, it's almost like a slope. So that started way before bail reform. So each year there have been fewer and fewer people detained on Rikers. And we also have to remember that when we see less jail detention, that COVID, there were a lot of people released because of COVID. So, and it was right on top of bail reform. It's a little bit hard to isolate any causality there. And then the other thing that we have been observing in New York is fewer arrests, which is similar to what was observed in New Jersey. But again, causality really hasn't been tested. There may be a lot of reasons for why there are fewer arrests occurring. Again, COVID changed sort of changed the crime patterns as well as policing. Police may have also been, feeling some or change their practices a bit in response to the anti-police sentiment. It's also important to keep in mind that when there are fewer arrests, that means there's totally different kinds of cases that are in the courts after bail reform versus before bail reform. So all of this is to say that there doesn't seem to be a clear relationship, or we haven't seen evidence of a clear relationship between these increases in crime, and suggesting that because this is a national pattern and we're seeing increases in violent crime throughout in other jurisdictions that haven't had bail reform, it seems unlikely that would be what's driving the increases in New York. And just about supervised release, there have been some comparisons made about recidivism among people who are on supervised release now. And I just want to point out that we have to be careful there again, because these kind of direct comparisons to the people that were on supervised release before are not really valid. It's totally different people. The rules about who gets on supervised release are completely different. And really an important thing that's kind of complicated to follow is that when someone's on supervised release, earlier studies have shown that it lengthens the time of the pretrial period. So as compared to someone who has bail set. So
I'd like to,
yeah, go ahead.
I'd like to go back to,
Sure.
what we started out with, sort of the nub of the problem is that, and really how journalists can write about this in a way that makes some sense to an audience which doesn't really understand data. What we're talking about in many of the jurisdictions that have had bail reform is not another reform of the reform. It's really basically a reversal of the bail reforms that, as I understand it, and maybe I'm wrong, but in many of the rhetoric that we're hearing from the opponents is that, it's a wrong idea, it's a bad idea, let's cut back even further. Let's just not, do what New York State did, add more reforms, more amendments to weaken the bail reform, but it's just a bad idea to begin with. So I'd like to ask all of the speakers, particularly maybe starting with Mr. Deberry, is, how you respond to that. I mean, do you see this as kind of an existential threat that if this continues, this basic cornerstone of justice reform is under threat, or do you see what's happened so far, both in North Carolina, perhaps, in New York City and in New Jersey? I mean, there are three different types of jurisdictions, as suggesting that there's much more of a resilience to the reforms that we can see from the outside, that these, despite the opposition, that these reforms can last and perhaps overcome the objections we're seeing. And obviously with that is how reporters, how journalists, the media, which is an essential player in this whole debate, how they can better report on it? How, what kinds of language they can use, what they should look for reporting, aside from just looking at the data. So maybe I'll start with you, Ms. Deberry, and then go again back to Mike and then to Cindy.
Yeah, I would hate to say aside from looking at the data, because I think the data is very clear.
Right.
It is
And how do you
very-
translate it? I mean,
Yeah, I think that is the story for journalists, is that data is increasingly clear that
point.
pretrial detention and the reform and bail reform have literally no influence on violent crime rates. I mean, here in our jurisdiction, of course, we've had an increase in violent crime, and specifically homicides, but literally every other category of crime is down, and it is down by double digits. I think, to Ms. Redcross's point, that is been the truth across the country. At crime levels and cases filed and people being detained is going down. And
I guess
so,
what's missing, I mean, that's a very important point, but what's missing is a positive part of that, is that, this has been an improvement in terms of public safety. It's an improvement in terms of the lives of the people who were most justice involved. This is what I was getting at with Mike.
Yeah.
We don't have the data so far to show that economically people are better off when they aren't forced to sit in jail because they can't afford bail. I mean, that's the positive way, I think, to report on it, to show that this is a net gain, not just that crime hasn't gone up, because people can always say, well, there are a lot of other factors for why crime hasn't gone up now, and maybe reform is one of them, but maybe it's not.
yeah, well, I'm not a researcher, so I don't know where we would even start to ask that question. But I think maybe what journalists could do is stories move people, and so more stories about what has happened to people who did not sit in jail. So if that is the lead story, they've certainly done a lot of lead stories about somebody who got out of jail and then killed their ex-wife or something. So
right, that's a very good point. Mike?
Well, yeah, I guess, okay, positives, negatives, and unknowns. That's complicated if you really want to do justice to all three categories. And, all I can really say to journalists is, please don't engage in stenography, meaning you might have various public officials or individuals who have opinions that are supported by no evidence. And so please don't engage in stenography. As far as these three complex categories, part of why I wanted to start earlier on the goals of bail reform is because the conversation has been so drawn into, I think, in the public narrative on the relationship between bail reform and crime, that we've almost forgotten three goals of bail reform: reducing pretrial detention, which has been achieved in New Jersey, clearly, as well as in New York, notwithstanding the partial version I discussed, but on balance, that's also been achieved so far in New York. And then criminalization of poverty, where we are having implementation challenges, and racial disparities, where we are having implementation challenges, but where the law itself suggests we might make progress. And so now we come to the bail crime relationship. And so as a researcher, I'm in this difficult position of saying, we don't know for sure. Could everyone wait for a truly meaningful and rigorous study comparing results in 2019 and 2020? But at the same time, Cindy has done such a study in New Jersey, and her findings are that there's no effect. And then when you look at overall crime trends, it actually looks like there's been this unexpected reduction after bail reform implementation, on misdemeanors. So we have this encouraging evidence generally, despite the public narrative and, the stenography of people who maybe aren't interested in informing the public with solid analysis, combined with, so we have an expectation that may be positive on the bail reform crime relationship, combined with, as researchers are wanting to be honest and say, but we haven't done the study yet, over a long-term period with a careful, rigorous analysis specific to New York's reforms, could we wait until drawing conclusions?
Thank you. Let me just very quickly go back to Satana again. If I understand that you're not feeling any pressure in Durham to pull back on bail reform at all. In other words, you're
Oh, I wouldn't say
is-
that.
you are okay. Well, that talk about that a bit. And
I mean, I think this is a good point for Mike to talk about stenography and about it kind of the tendency of folks like mayors and other folks who have
Right.
really strong opinions that are not backed by any research, and having journalists just kind of repeat that over and over and over and over again. I mean, here in Durham, we have really strong evidence that there has been, no effect, that this current rise in really just homicides has absolutely nothing to do with bail reform. And then the very first thing you might hear out of some people's mouths is, well, if they were just keeping more people in jail. And I assume, I have a primary coming up, and I assume that will be the constant refrain during this primary. But I think if journalists were kind of reporting, when I put out a press release or I talk about the research that we're doing with some really first-class researchers across this country around our pretrial detention policies and our plea policies, our plea tracker policies, we get crickets. Nobody wants to talk about it. I'll take that back. The Boston Globe did something on our plea tracker, but Boston is, I don't know how many subscribers they have in Durham, but we just do not get the response that we get if somebody like Eric Adams says, it's the prosecutors who are keeping us, who are causing all this violence or whatever.
Yeah.
And then I have journalists here ask me about that.
So we have very limited amount of time left. Good question from Mr. Johnson about whether the existence of community bail funds makes any difference at all to the politics of the situation. Do they have any importance at all? I don't know if each of you has run into that as either a data point or something that you've seen as a political sort of aid or assistance. And just moving over to Cindy, you all can answer that, but is there any room for compromise left in bail reform without totally weakening and undermining it? And this is obviously a political question, but if there is an opportunity, rather than to just, instead of reforming the reform, compromising or throwing the whole thing out, the baby with the bathwater, so to speak.
Oh, okay. This is interesting. There are certain. I'm not speaking for the district attorney, other than I know that she, as I said, supports bail reform overall. There are certain tweaks that she believes could be made that would make it a little bit more effective in terms of language. For example, I'm going to talk about one issue that she's currently focused on, which is it's focused on the raise the age aspect of legislation. And there is the law states that unless the youth, in terms of gun offenses, if a youth is arrested in possession of a gun, unless the youth displays that gun, then they can't be prosecuted in criminal court. And she would like to revise that language to say possession as opposed to displays a gun. So that's, it's little tweaks like that. And she is working with the legislature to make those tweaks. So I've never been of the opinion that bail reform is all or nothing. Many places are not comfortable doing with what Jersey did, where they eliminated bail completely. For example, in California, there's definitely not an all or nothing situation. There's a lot, little changes can make a big difference.
And the question of community bail funds?
Yes.
Satana, do you want to? Yeah.
Oh, sorry.
Well,
I'll-
either of you, yeah.
I think community bail funds are important for accountability. I think they reflect really what is probably actually going on in a community better than what the politicians are saying is going on. So I think they are important advocates and important balances. So
And there's a-
Oh,
Yes,
no.
Mike, go ahead.
Well, I was just going to add on community bail funds. I think they are so fascinating because, again, going back to the goals, one of the goals has to do with reducing criminalization of poverty. Okay, so but we have a reality where bail, this tool that historically and legally was supposed to facilitate release. People would pay money and then they would only get their money back if they show up to court. But in reality, it's used to detain people. So community
As a
bail
punishment.
So yeah, so community bail funds in effect are a way of community groups or whoever's going to run the bail funds sort of stepping in and filling a void in failing to have bail serve as this tool that facilitates release and saying, well, we are going to help individuals pay so that if they can't afford bail, they can still
Right.
get the release that legally and historically bail was intended to provide. So in that sense, they're a very sort of an interesting way of achieving this goal of bail reform, as well as achieving and realizing the original purpose of bail.
Right. So we have a question from Janae Williams that I'm going to send around to all of you afterwards. It's a more complicated question about collecting data. But what I'd like to do as we close the session is go around the room, the virtual room, and ask you how optimistic you are about the survivability of bail reform, both in your jurisdictions, New Jersey, New York City, and Durham, and nationwide. Who wants to start? Satana?
I'm optimistic. I think the North Carolina Constitution requires it. I think already sets up bail reform. And if we're actually kind of following our own statutes, that's what works. And, I kind of also want to remind people that we are talking about people who are pretrial detainees, people who are innocent. And so I think we also have to keep hitting at that point when people complain about, oh, well, you're letting these people go. We're like, nobody has been convicted of anything, and really require those people then to answer that question, as opposed to whether or not the release of people who have not been convicted of anything is dangerous.
Yeah, we're gonna get into that question, I think, in the next panel on prosecutorial misconduct. But let me continue the wraparound with a walk around with Cindy, and then Mike, you have the last word.
Sure. I'm pretty optimistic, and I'm optimistic because there were, in many of these jurisdictions, there were already trends in that direction. So, the places that embarked on doing something substantial with bail reform were already going to move in that direction. Otherwise, we would have seen even bigger effects. I mean, one thing I want to add, which isn't really related to the question, is that I hope that we can get to a focus once we, get past this, let's drop bail reform, let's fix the criminal justice system. Like, I feel like there's been great strides, at least in New York and New Jersey, in fixing the system, but it's not fixing the problem, as we can see, with violent crime and poverty and still the disparities. That means that the criminal justice system isn't the whole problem. And I hope that we can sort of turn our focus to prevention and really trying to better provide supports and services that will hopefully prevent these crime patterns from occurring to begin with. So.
Thank you, Cindy. Mike?
Well, I'm going to comment on, I guess, New York specifically, since that's where I know well. I'm also optimistic. Despite some of the conversation we've had and some of the conversation in the media, in New York, we do have leaders of our state government who have said that they're looking for evidence, actually, and they don't intend to change, bail reform anytime soon, absent evidence. So whenever we do have some political leaders making statements along those lines, we know we have reason for optimism, and we can all feel comfortable when we have evidence following it. I mean, as far as sort of going, beyond that optimism about keeping things as they are, I'm also optimistic that to the extent that we can refocus on evidence, we can again refocus on the multiple goals, look at some of the implementation barriers on people's ability to pay, and if and when we are ready to tweak, we can think about advancing some of those goals that some of the public conversation has led to be lost. So I do think all of this will happen. I don't think New York's bail reform is going to be rolled back absent evidence. And, hopefully with New Jersey having completed a study with what DA Deberry is doing in North Carolina, with a thoughtful approach that actually mirrors New York's in some ways, and having different approaches to different categories of charges. I think there is reason to think that even an evidence-based approach could extend nationally.
There's no doubt it's probably safe to predict that over the next 6 months, bail reform is going to be very high on the agenda of the election, the midterm elections, state elections. So it's not going to go away in terms of an issue. And I guess it's just a question of how we cover it. And you guys, I think, have your work cut out for you. So thank you very much for your time. I think we have to end it with this, but your names and contact numbers are going to be on our contact list, so journalists can contact you with any questions they have on everything we've raised today and other things. So thank you very much.
Thank you,
Both of
Stephen.
you, appreciate it. And we will take another, I guess it'll be now a 10-minute break. We're about 5 minutes behind schedule to go into our next to last session on prosecutor misconduct. That's panel 5. Thank you very much.
Thanks so much.
Thank you.